Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under land law 2, and I may see land law 2 and maybe equity and trusts. But anyway, land law. Today we are going to look at the doctrine of notice. That's why I've said that land equity, because doctrine of notice, it is both in land law and also equity. You get. So we are going to look at the doctrine of notice. And the doctrine of notice also acts on land, also under fraud, basically, because they say that you must know. There's a slogan of the slogan under sale of goods which says that caveat emptor, the buyer must also be aware. Let the buyer be aware. You get, the buyer must also be aware. You get, and there's also saying that he who comes to equity must come with clean hands. You get, that's also the maxim that I've got under equity. He who comes to equity must come with clean hands. But basically, nevertheless, without missing, once we go to the doctrine of notice. Doctrine of notice means actually it is the concept which refers to the knowledge of an existing what? Fact. You get, knowledge of an existing fact. And basically the rationale of the doctrine of notice is to prevent a buyer of superior title from setting it up against earlier owners of inferior interest on that particular land, which may affect the what? The property. You get, that is the rationale of the doctrine. You get, and its effect is that the buyer of the legal estate with the notice of the prior equitable interests affecting the estate takes it subject to the equitable interest, and in this regard he must consider the existing equitable interest on land. Failure to do it may lead to fraud. You get, so basically under the doctrine of interest, there's the case of the Zamora case of 1921. Under this Zamora case, basically they held that where there are two senses in a man, it is said not to know something because he does not want to know it. You get, a thing which is troublesome to learn, and the knowledge of it when it is discovered may be uninteresting or distasteful. Basically here they say that whereby something is troublesome, you must be eager to know something. You get, and if you pretend that you don't want to know about it, it is your own liability. It is your failure to fulfill that contractual obligation. It is your failure. It is your failure to make the precaution, the necessary measures to ensure that you are aware about of that certain fact or issue. You get, under the doctrine of what? The doctrine of notice. The case of the Zamora case. So basically under the doctrine of notice, we are going to look at the types of doctrine of notice or the categories. Basically we have actual notice. Basically under actual notice, this deals with, how can I say, actual notice that you have got knowledge of an existing fact. That is actual notice. That this is a situation where the buyer of an estate has actual or express notice or information of a prior interest in land. You get, you have an express or a prior knowledge of a particular interest in land at the time you purchase that land, or at the time the purchase is made, or by the time the purchase is completed. You have that existing information or notice or express term that there is an existing what? Interest on land. That is actual. And failure to make the needful, it will mandate to fraud. There's a case of Edward Gastinzi, Edward Gastinzi, G-A-T-S-I-N-Z-I, Gastinzi, and Mukasarita versus Ruanga Stephen. Under that case, the court implied that when a subsequent purchaser has actual knowledge, on an existing fact on land, or on the facts of circumstances that would impeach or would reasonably bring that caution person to make an inquiry when the purchase is being conducted. You get. Failure to do so, it will lead to fraud. You get, whereby you must take a measure of precautions which may reasonably be required for a prudent man or a prudent person in a like situation to make the necessary resolution. Failure to make it will amend it to fraud. That is actual notice. You really know what is happening. Then the second one is constructive notice. Constructive notice as an element of doctrine of notice. This implies where the purchaser has knowledge of any fact which may put him into inquiry as to the existence of some title or some right to title or some conflict on land or some prior interest on land at the time of purchase. And here, what do I mean by constructive? Constructive is that if, for example, if you go to land and they say that there are people digging on land, basically that is constructive notice. It puts you into inquiry. You get to inquire what's really the existence of those people. Are they lawful or bona fide purchasers? You get, so it puts you into inquiry. For example, even constructive notice, if you are buying land from a married man, probably you may ask that, did your spouse consent? That is constructive notice. It puts you in that line of inquiry. You have to inquire. And failure to inquire, it puts you in that element that you failed your part. You get, it will mandate to fraud. You get, so basically, actually it will mandate to a degree of negligence equally. Actually, they say that if for you who comes for equity, you must come with clean hands. Basically, you don't have clean hands. You cannot say, then, you know what, I didn't know that these people were existing on land. No, you had a constructive notice. You had a duty to inquire. You get to know that you have an existing knowledge that I've went to land, but I've found people digging from there. But you didn't take the necessary precautions to ensure that what are those people on this land? You get, there's a case of Lamoak Lance versus La Lawyer Jalon and another. You get, that case is under constructive notice, whereby the court held that constructive notice applies when a purchaser knows facts which made it imperative to seek an explanation, because in the absence of an explanation, it is obvious that the transaction was probably improper. You get, that is the case of Lamoak Lance. So read that case. Then the last one, we have imputed notice. Imputed notice. Basically, under imputed notice, unlike the other two, imputed, the notice which is a notice which is neither actual or constructive, but imputed, it is the notice that you get through your agent. You get, they say that who acts through the other acts for himself. So imputed comes in a way that if you send your agent to act on your behalf, any information the agent gets, it is imputed on you, even though you don't know about it. For example, if you have an agent and you send him to buy for you land, and the agent gets to know this land is lawful occupants, but for you are not aware. So if that agent goes into purchase of that land, the court will presume that that was an imputed notice. You get, that your agent was aware, it is presumed that you are also what? Aware. They impute it on you, even though your agent didn't tell you, that he who acts through the other acts for himself. That is imputed what? Imputed notice. And basically here, it actually there's a case of Sekaja. There's a case of Sekaja. Sekaja Nalima. Sejaka. Sorry, the case is Sejaka Nalima versus Rebecca Musoke. Sejaka Nalima versus Rebecca Musoke, where court held that the appellant was not a bona fide purchaser. Because for him, he was appealing that was a bona fide purchaser for value without what? Notice. But the court said no. Reason being that owing the fact that Musoke and the co-advocates were acting as her agents and had known of the alleged fraud concerning the disputed property, because they knew that the property was under family conflict, but for them they went ahead and purchased the property, that Musoka and co-advocates. So it was that notice was imputed on the what? On the appellant. So note that in mind. That is imputed knowledge, whereby knowledge may be proved a family or inferred from the circumstances. Knowledge of the nature may constitute to fact and may exist in various mental states. You get. So basically note that in mind. And what you have to know, or what you have to bear in mind under imputed notice, for it you get it from your agent or someone that you have subrogated the role to act on your behalf. You get. Court is not there to know whether by maybe you knew or you didn't know, so long as the person you sent to act on your behalf knew. That thing is imputed what? Imputed notice. So that is the doctrine of notice, and most of it is under land law, whereby they say that the buyer must also be aware of what you are purchasing. So it's not all about buying for if it is actual, you must be aware. We have constructive, you must make an inquiry where you feel that an inquiry is necessary, and there must imputed, your agent must inform you. You get. You can never claim being a bona fide purchaser for value without notice when you fall under those three categories of doctrine of notice. So other than that, thank you for listening and stay blessed. Wish you good luck and success.